Well, good morning, everyone, and a very warm welcome to this Brody's webinar on service charge, RAAC and ESG. So, introducing our speakers today, I'm Gareth Hale, a partner specialising in real estate litigation and based out of our Glasgow and Edinburgh offices. I'm delighted to be joined this morning by my colleague, Graham Imrie. Graham's a senior associate in our commercial property team based in our Aberdeen office. So looking next at what we're going to cover this morning. So what we're going to cover is RAAC and ESG. And our focus will very much be on whether landlords' expenditure is recoverable by way of service charge. We'll consider the extent to which the wording of individual leases matter. And we'll also touch upon one or two other issues along the way. Why have we chosen these topics? Well, we think that they're highly topical and interesting. There's been a lot of press coverage about both topics in the last 12 months, and they're two issues of high importance to commercial landlords and tenants right now. Parties rightly want to know where they stand on these issues, both under existing leases and new leases being negotiated. Added to that, we're starting to see an increasing number of disputes involving these topics, RAAC in particular. Thankfully, it appears that these topics are of interest to you too. We've had a terrific response to this webinar, and we're delighted to have so many of you join us this morning. Hopefully, we'll be able to give you some food for thought and send you away with at least a few points that will be useful to you going forward, whatever your role might be. I'll now hand over to Graham for a very quick refresher on the basics of service charge before we go on to look specifically at RAAC and ESG. Graham.
Thanks, Gareth. Good morning, everybody. Because we're focusing on service charge here, I thought it'd be really useful just to very quickly summarise what service charge is and the types of things that we'd usually see covered by one. Put very simply, a service charge is a mechanism contained in a lease of a multi-occupancy building, which allows the landlord to recover the running costs from the tenants. This generally includes things such as the cost of maintenance, repair and replacement of the fabric of the building, the plant or equipment, and any other works and services that the parties agree are necessary for the property's proper operation. Generally, the service charge will cover the repair, maintenance and running of the common parts of the building, and the tenants are left then to look after those parts of the building exclusively let to them themselves. There's quite often a bit of discord between landlord and tenant in relation to service charge. On one hand, the landlord regards the primary purpose of the service charge as enabling all of its costs to be met in order to achieve a clear rent without needing to make any deductions from that to pay for the services. The landlord therefore wants all expenses to be paid by the tenant wherever possible. If the property is fully let, the owner will normally be able to recover all expenditure on services through the service charge, except for any concessions that the owner may have given to any individual tenants in the building. On the other hand, the tenant generally regards the primary purpose of service charge as setting out the landlord's duties in relation to the provision of the services in the building. The tenant therefore wants to remove from the service charge all those items that the tenant thinks should be paid for by the landlord. One thing that's important to remember about service charges is that they're very property specific. So you can't just use a generic list of services that the landlord is going to carry out in every single transaction that you do. As an example, just think about how much more complex something like a shopping centre is when compared to, say, an industrial estate, where the only common areas might be the roads and perhaps some landscaping. It's important, therefore, that the service charge wording in the lease is given a good amount of thought when the drafts are being negotiated. There are a number of things that we typically expect to be excluded from service charge. Gareth's going to come on to talk about some of these in the context of RAAC in just a moment, but generally we'd see exclusions around the original setup costs of the building, so things like the original design and construction. Would exclude costs relating to the owner's investment interests, things such as the asset management, rent collection, perhaps the cost of carrying out rent reviews. We'd also look to exclude costs attributable to vacant units within the property, and perhaps understandably any costs arising out of the negligence of the owner or property manager. So I think that's a nice little segue there into the next section. So I'm now going to hand over to Gareth to give us a quick run through of RAAC and how this interacts with the service charge position. Over to you, Gareth.
Thanks very much, Graham. So RAAC, starting with the absolute basics, what is it? I suppose is the starting point. So RAAC stands for reinforced, autoclaved, aerated concrete. And as most of you will know, it was used extensively in the UK between the 1950s and the 1990s, and it continues to be used elsewhere around the world to this day. So it was manufactured in panels and was most commonly used in flat roof structures, but it can also be found in walls and in floors. Now, it was once regarded as innovative and cost-effective, and as a result, it was used in the construction of a large number of public buildings. But it wasn't just used in the construction of schools, hospitals, health centres, and other public buildings. It can also be found in shopping centres, office blocks, and residential buildings. It's believed that there are tens of thousands of panels within the UK building stock, but there is unfortunately no register to tell us where all of these panels might be. So when did RAAC really sort of come into the public consciousness? So I think worth saying that concerns about the longevity of RAAC have been brewing for quite some time. UK research findings on the risks associated with RAAC were first published more than 20 years ago. RAAC panels collapsed in 2 schools in England in 2017, and in 2018, a flat roof at a primary school in Kent catastrophically collapsed over a weekend. But the issue really came to the attention of the general public in the UK in September 2023. A matter of days before the start of the new school term, the Department of Education took the unprecedented decision to close 100 schools in England that were known to contain RAAC. Whilst most of these schools have now reopened, the issue was seared in the public consciousness. Not many people could have told you what RAAC stood for before September 2023. They can now. And added to that, in late August of 2023, the Health and Safety Executive published guidance to the effect that RAAC is now life expired and liable to collapse with little or no notice. And understandably, this got a lot of attention. This guidance had followed a conclusion published by the Building Research Establishment that RAAC had a 30-year lifespan. And since most buildings in the UK containing RAAC are now more than 30 years old, the thinking was that it was all time expired and therefore dangerous. So what's the current up-to-date guidance on RAAC? Well, I think probably fair to say that whilst there is still general and widespread concern, the picture isn't quite as bleak as it perhaps first appeared in the autumn of 2023. It's now generally accepted that the mere presence of RAAC of itself is not necessarily a serious concern for property owners and occupiers. The Institute of Structural Engineers have described the 30-year lifetime as an urban myth with little evidence to support it. The institution has said that many building materials are held to have a 30-year design life standard, and that this may be the true origin of the statement. It's remarked that RAAC has been investigated, which is much older than 30 years, and which, if well maintained, should last for many more years. Worth noting that the Health and Safety Executive has actually withdrawn its previous statement to the effect that all RAAC is life expired and liable to collapse with little or no notice. So it now seems clear, therefore, that the presence of RAAC in a building of itself is not necessarily a defect requiring any remedial works. So looking briefly next at the question of why does RAAC fail and what should building owners be doing to investigate it? So again, the Institution of Structural Engineers guidance says that if RAAC is manufactured correctly, installed correctly and appropriately maintained through its in-use life. And by way of examples, if it's not subject to overloading, and in particular, if there's proper management of water ingress, then the institution says that RAAC should perform comparably with similar materials. But it does acknowledge that RAAC can, however, creep and deflect over time, and this is exacerbated in particular by water ingress. Now, my understanding is that the main concern with RAAC is the bearings on supporting walls, and if these are insufficient and a panel's structural integrity is compromised, then it can fracture and collapse with little warning. So in summary, the current guidance suggests that whilst problems can and do arise during the manufacturing and construction phase, the problem with RAAC is often a lack of adequate maintenance and water ingress in particular. Building owners are urged by current guidance to carry out surveys and, where it's suspected that RAAC is present, to have a suitably qualified structural engineer inspect the building and develop a monitoring and management plan. Now, this plan is likely to involve, at the very least, firstly, monitoring, but it might also involve, secondly, remedial propping or strengthening works. And finally, it might include, in some cases, thirdly, removal and replacement of RAAC. And the institution describes this as a red, amber, or green rating. So having laid that groundwork, I thought we would move on next to look at what legal duties there are on building owners to investigate, remediate, and in some cases, remove and replace RAAC. So we're really going to look at sort of 4 issues here. So first, under a commercial lease, the necessary works can form part of the services which a landlord is obliged to provide in relation to the common parts of a building. That's really the focus of this morning's webinar, and we'll look at this carefully in a moment. Secondly, distinct from its service charge obligations, it's generally understood that a landlord has an implied obligation in common law to provide a tenant with premises and common parts that are wind and watertight and which are reasonably fit for the purpose for which they are let. Now, the landlord's common law warranty in relation to premises is usually discharged by the terms of a lease, but leases rarely discharge a landlord's common law warranty in relation to the common parts. So even if not a landlord obligation under the service charge provisions, a landlord may still owe obligations to tenants to deal with RAAC under the common law. Now, thirdly, as the owner and occupier of parts of a building, the landlord will have statutory duties. So, for example, under the Health and Safety at Work Act, there's a duty to ensure that so far as reasonably practicable, premises are safe and free from risks to health. Separately, the Occupiers Liability Scotland Act imposes a duty on landlords to take reasonable steps to keep visitors to the building reasonably safe. And a landlord is likely to be obliged under both of these acts to take reasonable steps if RAAC is found in its building. Fourthly, and finally, a landlord has a common law duty in respect of the common parts to take reasonable care to avoid injury to persons or damage to property. And this duty is likely to be engaged when RAAC is found in a building. So really coming around to the sort of meat of this part of the presentation, which is what are a landlord's rights and obligations under the service charge provisions in a lease. So I think firstly and most importantly, we're going to look at the obligation to repair. And generally under the service charge clause, a landlord will be obliged to repair the common parts of a building. So the first question which arises is, does RAAC amount to disrepair? Well, as we've discussed already, the mere presence of RAAC in a building does not automatically mean that there is disrepair. In thinking about the costs which a landlord incurs in investigating and monitoring RAAC, these are likely to be recoverable as service charge so long as they are actually linked to the obligation to repair. If, for example, investigations are made and no RAAC is found, it may be difficult for a landlord to recover these costs as relating to repairs, though they may be recoverable on some other basis. So if RAAC is found, and ongoing monitoring or remedial works to prop or strengthen are recommended, then I think it's generally accepted that these costs are likely to be recoverable as repair costs. But what if the work required involves much more than that and involves wholesale removal and replacement of RAAC planks? Does this fall within the landlord's obligation to repair, making the costs recoverable from tenants under the service charge? So my own view, for what it's worth, is that it does, subject only to the possibility that a landlord and tenant might have specifically agreed in their lease to exclude from the services works to the common parts which are necessary because of latent and inherent defects. Now, this is generally understood to be the position in England and Wales by most commentators. The position in Scotland is, however, arguably complicated by the Scots law concept of extraordinary repairs. So moving on to extraordinary repairs, the question really is, are RAAC repairs extraordinary repairs? And if so, does it matter? So those of you who are involved with dilapidations claims will be familiar with the concept of ordinary repairs and extraordinary repairs. And thinking about a tenant's repairing obligation, at common law, a tenant is responsible for ordinary repairs only. And extraordinary repairs include those necessary as a result of latent and inherent defects or the mere passage of time. Now, most leases will exclude the common law and will make a tenant liable for both ordinary and extraordinary repairs. And commercial leases achieve this by including wording along the lines of the tenant is responsible regardless of the cause of damage. So pause there to ask the question, are RAAC repairs extraordinary repairs? I think the unfortunate answer is, well, that depends. But they certainly could be if the repairs are necessary because of latent or inherent defects or the mere passage of time. So if RAAC repairs can be extraordinary repairs, the next question is, does the concept of extraordinary repairs matter when considering a landlord's service charge obligations as opposed to the repairing obligation imposed on a tenant in relation to the premises? And personally, I don't think that it does matter. I think that a simple obligation on a landlord to repair will include both ordinary and extraordinary repairs. And that view is supported by authority from the Inner House, the appeal court of the Court of Session from the early 1990s, a case called House of Fraser against Prudential Assurance. There is, however, more recent case law from the Outer House of the Court of Session dating from 2016, a case called AWG Business Service Centres Limited against Regis, which suggests that it is important to look at the wording of the clause imposing a repairing obligation on the landlord and to check whether that clause includes ordinary as well as extraordinary repairs. In that case, which involves repairs to the concrete deck of a recently constructed car park, the court felt it important that the lease imposed an obligation on the landlord to carry out and a corresponding obligation on the tenant to pay for repairs irrespective of the cause. So we are left with a slight tension between these two authorities. Now, my own view, as I said earlier, is that a landlord is responsible for and a tenant is obliged to pay for all repairs, including RAAC repairs, except those which the parties may, by the terms of their lease, specifically choose to exclude. So that's my view, but if we look next at the market view, it's clear that the market is actually pretty jumpy about this issue. And I put up on the screen the PSG style clause for a multi-let office building. And this is based on the English model commercial lease, which no doubt a lot of you will be familiar with. And the service charge provisions include the clause that I have put up on the slide. Now, I won't read this clause in full, but what I have done there is underlined the most relevant sections. And I think what it's clear is that these underlined sections are obviously aimed at ensuring that a landlord is obliged to carry out and is entitled to recover the cost of extraordinary repairs. So I think the point there is that the market is perhaps unsurprisingly not willing to trust that the common law provides clear answers. So moving on to the next slide, I suppose a sort of really important question here is the question of, is it possible that, depending upon the terms of their lease, a tenant will seek to argue that RAAC repair and removal is an extraordinary repair outside the scope of the landlord's repairing obligation and therefore outside the scope of the service charge? And I think the answer to that is yes, of course it is. Tenants will inevitably seek to exploit any argument which means that the cost of RAAC repairs is a landlord liability. But to revisit a question posed earlier, are RAAC repairs actually extraordinary repairs? I think, again, to repeat what I said earlier, they will be if they're necessary because of a latent or inherent defect or the mere passage of time, but not if they're necessary because of a lack of maintenance. And clearly, this will need to be assessed on a case-by-case basis. And this really raises a further interesting question. If RAAC repairs or removal are necessary only because of a failure of the landlord to maintain over a period of time, should a tenant be liable at all? That's not a question I'm going to answer this morning, but it is a question which the courts may have to answer in due course. So looking very briefly now at, in addition to the repairing obligation, the other parts of a service charge clause which a landlord might be able to rely upon. Well, as I mentioned earlier, a landlord will generally have an obligation to comply with statute, and this will form part of the service charge provisions. Now, this would generally include an obligation on landlords to carry out works necessary under, for example, the Health and Safety at Work Act or the Occupiers Liability Scotland Act 1960. So I think even if it was determined that a landlord's repairing obligation was not wide enough to capture RAAC works, any works reasonably required to keep the premises safe for employees and visitors may nevertheless be recoverable as service charge on the basis that these are works which the landlord is obliged to carry out by statute. And secondly, just a very quick word on the concept of good estate management, always slightly wishy-washy, but I think the point could be made that if not recoverable under any other part of the service charge clause, works to repair or remove RAAC might be justifiable on the basis that they're necessary for the purposes of good estate management. Now, it's unlikely a landlord would want to rely upon this provision in isolation, but it might be a useful supporting argument if there's any ambiguity about the applicability of other more specific provisions. Now, as Graham mentioned earlier on, it is important also to look at any specific exclusions contained within the service charge provisions, because these are obviously works, the cost of which will not be recoverable from tenants. So these exclusions typically include landlord redevelopment and upgrade costs. They will also normally include repairs necessary because of an insured risk. And there has been some commentary in relation to insured risks and RAAC. But the prevailing view, I think it's fair to say, is that buildings insurance policies will not generally cover the cost of RAAC monitoring, repair or removal and replacement. So RAAC repairs won't generally be excluded from the service charge via the exclusion for insured risks, but clearly individual policies will need to be checked on a case-by-case basis. The final point in relation to service charge exclusions is that these come in all shapes of and sizes, so they will need to be checked on a case-by-case basis. And you do sometimes even find provisions which provide that landlords can only pursue costs as service charge in the event that they have first exhausted remedies against any third parties who might be liable. Now, a discussion on whether a landlord might be able to pursue original developer, architect, contractors, etc., is clearly beyond the scope of this webinar. But I think suffice to say that that's likely to be fraught with difficulty, not least in relation to prescription limitation. If you do come across a lease with such a clause, then great care will have to be taken before this cost is passed to tenants as service charge. So finally, before summing up on RAAC, I thought I would look very quickly at what the position is where repairs are necessary to the let premises rather than to the common parts. I think the general rule there is that the cost of RAAC repair or removal and replacement to the let premises will be for a tenant, assuming that a lease makes the tenant liable for extraordinary repairs. But worth adding that even where a lease does not make a tenant liable for extraordinary repairs, a tenant may nevertheless be liable if a landlord is able to prove that the works are only necessary because of a tenant's failure to carry out ordinary repairs during the course of the lease. So, for example, if ordinary repairs would have prevented water ingress, which would in turn have prevented the RAAC deteriorating to a dangerous state, then a tenant may still be liable. And separately, I think final point worth making is that a tenant will also generally be on the hook for any works required by statute. So that may be an alternative route to imposing liability on the tenant. So that really brings me to the conclusion of the part of this webinar focused on RAAC. So I thought I'd just sum up with some key points to take away. And I've listed sort of 5 points on this slide. So I think the first point to take away is that the presence of RAAC of itself does not automatically mean that there is disrepair in the common parts. Secondly, initial guidance that all RAAC was time expired and liable to collapse has now been withdrawn. Thirdly, that RAAC must be inspected on a case-by-case basis and a bespoke monitoring and maintenance plan put in place. Fourthly, that the cost of RAAC repairs and removal and replacement will usually be recoverable as service charge. But fifthly and finally, we can definitely expect to see tenants deploy all available arguments that because of the terms of their particular lease, RAAC is a landlord liability. So that was all I had to say on RAAC, and I will now hand over to Graham to talk to you about ESG.
That's great, Gareth. Thank you very much. So environmental social governance, commonly known as ESG, has become a critical consideration for businesses and organizations everywhere. I think the significance here is twofold. Failure to address ESG may have a serious financial and reputational impact for companies, but there's also recognition that there are significant opportunities for organizations who address and really embrace these factors. As investors, customers, regulators, and society as a whole is becoming more aware of ESG, it's become a fast-moving and complex area for businesses and organizations to have to kind of navigate and manage. When it comes to leases, though, the most prominent strand of ESG is by far the E, environmental. Businesses are increasingly accepting the fact that the environmental performance of the buildings they own and occupy is not an issue that they can ignore, and they're recognizing that it's now an integral element of business risk management. Whether limiting regulatory risk exposure, retaining asset value, ensuring business continuity, meeting client demands, reducing operational costs, or even just managing reputation, the drivers are strong and they're just going to continue to grow. For a large percentage of commercial buildings, a key problem is the relationship that exists between the owners and occupiers. A historical adversarial relationship and lack of trust often exists between the parties, and this can present real barriers. Now, many of you will have heard of the phrase green leases before, and it's through these green leases that many of the sustainability factors in a building are accounted for between landlords and tenants. So what exactly is a green lease? Well, to deal with a common misconception, a green lease is not a specific type of document, and there's currently no industry standard green lease in place. Instead, it's better to understand the concept as being a series of provisions that can be inserted into the types of leases that we already use. This could be a clause, a schedule, or an entirely separate document that's designed to provide a framework for engagement on environmental issues, and they enable the parties to better understand each other's environmental aspirations and identify opportunities for collaboration. These provisions generally enable owners and occupiers of buildings to work together to reduce environmental impact of the buildings and also to improve sustainability. And typically these provisions will deal with matters like reducing carbon emissions, compliance with energy efficiency regulations, waste reduction strategies, green transport measures, and also reporting on these matters in a standardized fashion. One of the more important things that a green lease would seek to cover is sharing of data and information about a property between the landlord and the tenant. Without this, it's impossible to plan strategies for improvement of the environmental performance. As a minimum then, you'd want your green lease to have an obligation for the landlord and tenant to share the relevant data. In some cases, and particularly for modern buildings, the property might already have a system in place for the measurement of the energy and water supply to each premises within the building. This might allow the landlord to review and monitor the data without having to involve the tenant at all if they can do that remotely. But as I said, this is probably only going to be the case with really modern properties. So again, a data sharing clause is really important. Generally speaking, a landlord will be able to do work to meters unilaterally where those meters are located within the common parts of the building. Although, as we'll come on to see, depending on the service charge wording of the lease, the landlord might not be able to recover the cost of this from the tenant, and the landlord might also have to time the work so as not to breach any of the provisions of the lease regarding not causing disturbance to the tenant. Tenants will, on the other hand, usually need to consent to landlords carrying out works within the extent of the leased property itself. So in terms of a potential draft clause to cover this off, I've put one up on the slide here. And this covers off the sharing of all types of data, as well as allowing the landlord the right to access a property to install meters, etc. So you'll see on the clause, the landlord and tenant will share the environmental performance data they hold relating to the premises. This will be gathered on a regular basis, and then we've got a square bracket there which has a timetable to be agreed, and that will be shared with the manager and any third party who needs to see the data. You might also want to include additional wording to cover off keeping the data confidential between the parties. The landlord may also, at its own cost, as you'll see on the next slide, install equipment such as meters, etc., to measure the supply of gas and other utilities entering the premises, and then the landlord would have the right to enter into the premises at reasonable times to carry out works, provided that A, reasonable notice is given to the tenant, the installation of equipment won't adversely affect the tenant's beneficial use of the property, and C, the landlord makes good any damage caused. So these are the sort of usual entry safeguards that the landlord would need to comply with when entering into a property. So we've covered off metering, but what about the landlord's right to actually go in and do more substantial works to a property? So I think one thing the landlord may wish to consider is whether they want the ability to do those works which will enhance the environmental performance of the building. There needs to be a careful balance, though, between the needs of the landlord on one hand and the tenant's right to freely enjoy the property without interference from the landlord on the other. If the landlord is to be permitted to enter into the actual tenant's premises to carry out works, then you'd expect to see the usual safeguards that I just mentioned to cause as little disturbance to the tenant as possible. However, it may well be the landlord wishes to carry out works to the common parts of the building, thinking such as improved insulation, for example. And suggested green lease clausing to cover this off would be the wording that I've got on the slide just now. So the landlord is entitled to carry out works to the common parts and to the plant and equipment serving the building, which are intended to improve the environmental performance, notwithstanding any interruption in the provision of services, provided that the landlord will use reasonable endeavours to minimise that disruption. So generally speaking, a landlord would be free to carry out improvement works to the common parts or common plant and equipment without restriction, because generally nothing in the lease would prevent what the landlord does with its own parts of the building. However, where the landlord is obliged to provide services, carrying out the improvement works may interrupt this in a manner that's not authorised by the lease. So in those circumstances, the last part of the clause that's on the screen there will permit the landlord to do the work notwithstanding the interruption to the services. So it's a useful thing to have in the lease. So how does all that fit in with the service charge? So the drafting that I mentioned here doesn't set out how the cost of these works would be borne, but I would expect that most improvements of this nature wouldn't fall within the recoverable costs under the service charge. Ultimately, and this is important to remember, is that a commercial lease in Scotland is ultimately a contract, and the parties are generally free to put whatever provisions they like into that contract. So if the landlord did want to recover the cost, then they would need to be specifically included as a recoverable head of expenditure. And likewise, the tenant should also check the service charge wording really carefully so they don't get any unexpected surprises. More generally on service charge, landlords will seek to recover many of the costs associated with environmental provisions from the service charge if they can. This could include installation of new technologies or purchase of carbon allowances, carbon offsets, and so on. On the tenant side, though, the tenants will probably look to carve out energy-related improvements and services. This is because the tenant won't want to invest in improvements to increase energy efficiencies unless they're also to receive a benefit, perhaps most obviously in the form of reduced utility bills. So a landlord may look to try and charge the tenant for the cost of improvement works through the service charge, on the basis the tenant will get reduced bills. However, on the other side, the tenant may consider that such improvement works will increase the overall value of the landlord's investment and the future prospects of letting the premises, so those costs should be properly met by the landlord. So I think what you can gather hopefully here is that there's two quite conflicting places the tenant and the landlord are coming from in terms of what they're interested in when it comes to ESG requirements in a service charge clause. So I think it's really worth the parties agreeing at heads of term stage what, if any, environmental provisions will be included in the service charge. And it's important to be clear on this, as the PSG style lease, which, as Gareth says, many transactions are based on these days, actually has very few opportunities for a tenant to challenge service charge. Unless there's an obvious error, the standard wording says that disputes can only be raised within 4 months of the service charge statement being delivered to the tenant, and that any dispute should be handled by alternative dispute resolution means before resorting to court proceedings. And the reason that I mentioned disputes here is because if the landlord is intending to carry out services at a property, it's probably fair to assume that the cost of standard services will be lower than the cost of obtaining sustainable or more environmentally friendly services. I'm thinking here of an example of an energy tariff for lighting the common parts. If that's a renewable only energy tariff, it's likely to be more pricey than just a standard one. Or if the landlord's using materials from sustainable sources, they're likely to be more expensive than materials from non-sustainable sources. So a well-drafted lease will allow a landlord to legitimately include these potentially more expensive environmental items in the service expenditure if it's for the benefit of the building. So I've put up some lease wording on the slide here which covers off this point. The tenant is not entitled to challenge any element of the service cost which may have been procured at a lesser expense, where the increase in cost is as a result of the landlord procuring services which promote the environmental performance of the building. You'll see that the wording in square brackets at the end of the clause here contains a cap on the cost of the environmental items being no more than 10% higher than the cost of regular items. As with a lot of these things, this would be a number that's open for negotiation, and the landlords may actually have this, or may look to seek to have this number uncapped in certain situations so that they can recover the whole of any such costs. This would be negotiated on a case-by-case basis, and it's largely down to the negotiating power of the parties and how prominently ESG features on the landlord's agenda. If the landlord is truly focused on ESG and wishes to have carte blanche to use as many sustainable materials as they wish in providing the services, then the lease would need to clearly cover this and make sure that if there was a cap, that it was at a sufficiently high level. A slight variation to this is the second half of that slide. This is a more general catch-all approach, which allows the landlord flexibility to improve the environmental performance of the building. So that clause says the landlord is entitled to have regard to the environmental performance of the building, and the tenant acknowledges that as a consequence, the service cost may be higher than if the landlord procured building services without due regard to promoting environmental performance. So the wording in square bracket, I think, actually goes quite far, but it would be really useful from a landlord perspective in firstly ensuring that any ESG schemes implemented by them will be repaid by tenants via the service charge, and secondly, that the landlord has as much flexibility as possible to implement their ESG agenda. I think the key theme that I'm really trying to get across here is that there's a huge benefit to setting out clearly at the outset what the responsibilities of each party is under the lease. If the tenant's going to be paying towards environmental upgrades to the building via the service charge, I think we also want to be clear what exactly the services are that the landlord is going to be provided. And the next slide, I've put a few examples of things that probably would want to be included in the services. So we're talking about installation of technology, landlord taking steps to reduce water wastage, paying all taxes and levies that may be associated in respect of carbon emissions or any other environmental impact related to the premises, obtaining professional advice, which is designed to improve the environmental performance of the building. Points, I guess the third and fourth points are probably quite radical and a bit of a departure from what we're used to seeing in commercial leases. You typically see the landlord being permitted to take professional advice in relation to their operation of the building, most obviously via the managing agent. However, I think this final point goes a step further and allows the landlord to appoint specific environmental consultant to audit the property and then to recover the cost of that from the tenants. Just as a final note, the cost of obtaining an EPC is not normally considered to be a recoverable cost with service charge. EPCs are only required when a building is sold or rented, and therefore it's of no relevance to the ongoing management of the common building services. So as a tenant, you should always resist EPCs being included in the landlord's services. And ultimately, the majority of what I've just been through just now is a lot simpler to put in place when a new lease is being agreed. It's much trickier to try and deal with a lot of these matters for existing leases, particularly if the lease is old and predates concepts such as ESG. For these older leases, you're very much bound by the constraints of the document, and whether or not a landlord is able to recover the cost of any environmental improvements via the service charge will really be on a case-by-case basis. I'd say then that at the expiry of any old leases or when any re-gears are being discussed, landlords should take the opportunity to update their standard leases for the building to include any flexibility that they require to allow ESG costs to be properly recovered. And of course, we're very happy to assist with any of that drafting. And that's my sales pitch at the end of that there. And I think that's the end of the sort of beef of what we're going to be talking about today. Should we just see if we've got any questions here, Gareth? We do have another question here, Gareth. Are you aware of any reported cases relating to RAAC coming from the Scottish courts?
Thanks, Graham. No reported cases so far as I am aware, and similarly, I'm not aware of any cases sort of making their way through the court system in Scotland where a substantive hearing is imminent. But just looking at our own practice, you know, we do have a number of instructions in relation to RAAC disputes. So I think it's probably just a case of watch this space, and there may be some cases coming before the courts in future. And I think probably, Graham, having regard to time, I think all that really remains to be said is just to really thank everybody for attending this morning. I hope you have found it useful. Hopefully there has been a couple of points that you are able to take away. So on behalf of Graham and I, thanks very much, everyone, and hope you have a good day.
Thanks, everyone.